In domestic violence situations, it often starts with just an argument, stress from work, a bad day, tension building. Then, before you even realize what's happening, voices are raised, things escalate, and suddenly the police are at your door. Now you're facing a domestic violence charge, and what happens next could change your life forever. I'm Nana Knight, a former prosecutor and a California State Bar board-certified criminal law specialist, and I've seen firsthand how these cases unfold. But here's what most people don't realize. There are ways to fight back if you're wrongfully accused. In this video, I'll break down 3 crucial strategies you can use to beat your domestic violence case if you're wrongfully accused and protect your future. Strategy number 1, attack your case before you're even charged. How do you do this? Convince the prosecutor not to file the charges against you. Remember, being arrested does not mean you're going to be charged with a crime. When you've been arrested, the police write a report, but they don't have the authority to file the case against you in criminal court. It's the prosecutor or the district attorney who reviews the police reports and decides what charges, if any, should be filed. The prosecutor has the authority to file whatever charges they think are appropriate based on the facts and the law, and sometimes they can decide to file no charges at all. Sometimes the prosecutor will look at your police report and throw out the entire case in the interest of justice, or due to insufficiency of the evidence. If the prosecutor reviews your report and declines to file charges against you, that's a great outcome. Using this first strategy of attacking your case before you're even charged, your attorney can provide the prosecutor character letters from people who know you, present your life story in detail, especially if you've overcome hardships, or any classes you have taken like counseling, rehabilitation, or therapy, any community involvement, proof of employment to show that you are a productive member of the community, or any other evidence to show the prosecutor that you're not a criminal. Your attorney can present your defense and go into detail about what really happened during that incident, and hopefully the prosecutor will agree that you should not be charged with a crime. After being arrested, many people take a passive approach and they just sit and wait to see what the prosecutor will do with their case. You should not wait, and instead, you should consider taking on a more proactive approach with your attorney to convince the prosecutor not to file charges. Number 2, attack the state's investigation immediately after the case is filed. When charges are formally filed, you now have to go to court. And when you go to court, you will get all the evidence that the prosecutor is using against you, including police reports, body-worn camera videos, 911 calls, photos, statements by witnesses, and sometimes even medical records. Your attorney will look at all the evidence the prosecutor is using to convict you, review everything with you, and look for any inconsistencies or evidence of self-defense, mutual combat, alternative explanations of any injuries on the alleged victim, or injuries on you that may show self-defense, or an attack by the alleged victim. Your attorney can look at evidence of any prior fabrications or prior lies by the alleged victim and any evidence of lack of credibility by the alleged victim. The body-worn camera footage is especially important because the police report does not always match what's on the body-worn camera. An example is if the police report states that you hit the alleged victim, but we review the video of the interviews, and the victim never mentions you hitting them. So your lawyer can also gather more evidence by doing an investigation that is helpful to you. That includes interviewing witnesses, interviewing the alleged victim, collecting past text messages, for example, or any videos or any photos. Your lawyer can look for problems in a law enforcement's investigation, such as failing to interview material, important witnesses or eyewitnesses, or failing to conduct important follow-up steps. Your lawyer can provide this new information to the prosecutor as part of your defense. If the prosecutor is convinced that they can't prove the charges against you beyond a reasonable doubt, you have a good chance of getting your case dismissed. Number 3, expose the truth during jury trial and object to the evidence. When you take your case to trial, the prosecutor has the burden of proving that you are guilty, and that has to be done beyond a reasonable doubt. That's the prosecutor's burden of proof. This is a very high standard of proof, and the prosecutor is not always able to meet this standard at the trial stage. So when you're in a jury trial, you're trying to show the judge and the jury that the prosecution cannot meet its burden of proving your guilt beyond a reasonable doubt. And you can do that by exposing the truth of what really happened. Your lawyer will get an opportunity to cross-examine the alleged victim to expose any prior lies, falsification, fabrication, any inconsistencies, any evidence of bias, or any evidence of retaliation. or even the alleged victim's character for violence. This is also an opportunity for your lawyer to cross-examine the officers who did the investigation and point out any defects in their investigation, any gaps in the investigation, any problems. For example, were there any other witnesses at the house and the cops didn't take the time or make the effort to talk to them? This could be a problem. Your lawyer can also object and keep out evidence that the prosecutor is using against you. For example, the prosecutor is trying to play the 911 call for the jury or the judge. Well, the prosecutor has to meet the technical foundational requirements before the judge allows this call to be played in court for everyone to hear. Here, your lawyer can object if the foundational elements of the call are not met and keep out the evidence that the prosecutor is using to convict you. If you or a loved one is facing a domestic violence charge in San Jose and you believe you've been wrongfully accused, you need answers to defend your freedom and your future. We offer free consultations at the number on the screen, or check out the link in the description for free resources on our website to prepare your defense.